Hi, I'm Neil Hamilton, a professor of law at Drake University in Des Moines and director of the Agricultural Law Center. I want to welcome you to another installment of our series, Law for Landowners, 10 Things You Need to Know. Today our subject is water law in Iowa. Water is essential for life and for agriculture, and when it comes to farmland ownership in Iowa, there are really three questions to consider. Who has the right to use water? How do you go about draining water? And what do we do to keep water quality clean? And the first point to consider is that historically, Iowa is what's been known as a riparian state, which means that the people who live next to water, like a river, or a stream, or a lake, have the right to use it. Riparian water rights are in contrast to what's known as prior appropriation, the type of water law that you find in western states, where the right to use water is based on who put it to use first. In a riparian state, it's who's next to the water. The second point to understand, though, about water law in Iowa is that there's another system, which is known as a permit system, which means that the right to use water is based on you obtaining a permit from the state. And in the 1950s, Iowa adopted this legal system by declaring that all of the water in the state is the public's water, and that to be able to use it, you need a permit from the state. The third and key point to remember from this change to a permit system is to understand when you actually need a permit and which types of water uses don't require a permit. So the third key point to remember is the difference between a regulated use and a non-regulated use, because that's going to determine whether or not a permit is required from the state. The fourth point to consider is that regulated uses, those requiring or using more than 25,000 gallons a day, withdrawing it from a water body in the state, are going to require a permit. And that permit will be subject to the conditions that are established by the Department of Natural Resources and under Iowa law. A key to remember here is if you're using less than 25,000 gallons a day, you're a non-regulated use, and it means you don't need to use a permit. Most households and farm operations are going to fall within this level of less than 25,000 gallons a day. A fifth point to consider, though, is if you do need a permit to make a beneficial use of water, then you're going to have to apply to the DNR and to follow their procedure and to obtain a license from them. So the sixth point to consider is that when you apply for a permit with the DNR, they're going to investigate to see how that withdrawal may affect the other uses, other people that have permits, the in-stream uses, and how it may affect what's actually left in the water course that you're withdrawing the water from. The state doesn't have to approve the permit if in fact they determine that this withdrawal will have a negative impact. A seventh and important point to remember about Iowa water law is that the right to use water that you can obtain through a permit is tied to the property on which the water is being used. In many states, the issue of whether water rights can be sold and the water transferred to other property is an important issue. In Iowa, that's not allowed because, again, the water rights and the ability to use it is tied to the property for which the permit is obtained. An eighth issue that can come up concerning water use in Iowa concerns the water that's in farm ponds and whether or not people are able to use it. Iowa law protects the rights of landowners to use the water that's been impounded in farm ponds on their property. Part of the value of having a permit system is that the state's able to establish a set of priorities for water uses and what might happen in case of a severe drought. Under the Iowa law, different types of uses could in fact have their permits terminated if we were short of water. Irrigation is one of those uses that could be shut off, whereas on the other hand, livestock has a much higher priority because of the importance of being able to provide livestock with water. A 10th and final point to remember about water law in Iowa concerns the issue of surface water and groundwater. For the purposes of the rights to use or withdraw water, Iowa law doesn't make a distinction between them. But you do have to get a permit from the state if you're going to drill a well and withdraw groundwater and use it. And so those are 10 of the important points to remember about water use in Iowa. If you do have questions, though, or if you're concerned about the amount of water you're using or how the water used by a neighbor may be affecting you, I'd encourage you to either contact the DNR or to talk to your attorney.